Now, more compelling talk radio 1320 WILS is live in Lansing with the Michigan Association of Broadcasters Excellence Award winner for Best Personality. This is the Capital City Recap with Michael Cohen.
Well, it's Wednesday. Michael Cohen, producer Solomon Martin, thanks for joining us tonight. We'll find out who really won the Republican presidential debates and go through some of the exchanges, some very surprising. Also, Robert Spencer will be here, the director of Jihad Watch. I'll get his take on those that say that there's a growing hateful rhetoric against Muslims. But first, today, the judge in the Freddie Gray case, the first case, actually, one of 6, calling it a mistrial in Baltimore. What's ahead and how did this happen? Let's talk to Scott Palmer, a defense attorney and legal expert, scottpalmerlaw.com. Scott, thank you for joining us.
My pleasure. Thanks for having me on.
Yeah, and this was what they deliberated for, 16 hours? Is that an extremely long time for a jury to deliberate?
Extremely long time for any jury to deliberate on a criminal case. They had multiple charges that were that they could have come to a verdict on, and they couldn't come to a verdict on any of them, which is surprising, but actually not surprising because apparently this case has been noted to be pretty much the weakest case to go, which was surprising is that they went on this case first. Nobody quite understands why they would take the weakest case first.
Does this affect then, because there's 6 cases, does this change the strategy for the rest of the cases once this happens?
Well, you would think so. I mean, the prosecution is going to have to kind of double back and figure out what they're going to do with Mr. Porter himself. Are they going to retry him? They pretty much have to, I think. With deliberations that long, it looks like they had 1 or 2 holdouts. But the question is, which way was the jury leaning? Was it for guilty or not guilty? They have also 5 other defendants to consider and pretty strict guidelines and timelines that the judge has set on trying all of these cases. So this is definitely not what the prosecution wanted, and the defense attorneys are obviously happy and overjoyed that they were able to poke holes in the story. Yeah. From what I understand, they were saying all along that the case was weak and that the prosecution could never make the case as they laid it out in open. Because
they charged him with manslaughter, assault, reckless endangerment. And right. This is because he did not provide a medic. He actually testified, Mr. Porter, right? He said that he thought that Freddie Gray did not really need a medic, that he was not telling the truth, and then that he didn't buckle him in. Do you think the charges were inappropriate for what he did?
Well, it's more of an omission. It's hard to, when you're trying to get somebody to be culpable, legally responsible for the death of an individual, when you failed to do certain things, failed to call for a medic when someone said, I need a doctor. And, I don't believe that, that Porter or any of the officers thought that Mr. Gray had a lot of credibility, so they didn't believe that he needed a doctor. And the seatbelt issue, apparently they were all trained to, as cadets, to use seatbelts, but nobody showed them how to do it. I'm not sure how hard it is to seatbelt somebody in, but they claim that they don't seatbelt people in the paddy wagons for officer safety. So it just seemed like a stretch to be able to put the death of Freddie Gray on this particular officer for these failures. It didn't seem like that. It seems like the jury agreed that this is probably a stretch to hold him accountable for his death based on these omissions.
He testified. He's testified, quote, "It was traumatic for me also." This is Officer Porter. He said, Freddie Gray and I we weren't friends, but we had mutual respect. Do you think that can trigger a jury, or at least some jurors, to hold out when they hear someone on the testifying themselves this way?
Yeah, I mean, he's an officer, number one, so he's going to have some credibility, whereas, a non-officer defendant may not have that credibility. I think he did a very good job of testifying and kind of holding his own and explaining his role and his connection to Gray. I think they actually, from some of the reports I've read, that he had known him in the past. Nothing serious, but I think Mr. Gray had been arrested several times, and that and these Baltimore officers apparently had come across him. But I think that resonated with some serious impact with the jury, that the officer basically showed the emotion from his perspective. And again, he's an officer doing his job or failing to do his job as the prosecution laid out. But I think that this was going to be a difficult case to get a conviction on, no matter how they tried it.
So are they going to likely have a better shot with the other officers, you think?
I think it's hard to say. This is a litmus test. They may have to really reconsider whether they're going to, what strategy they're going to use for the other officers. There's different allegations on different officers. And again, this was the weakest case. They should have started with the strongest case.
And they were going to use him, right, this Officer Porter, they were going to use him as a material witness against the driver of the van. Now, does that change their strategy of doing that now that this has been a mistrial?
Well, I don't know how they would use him as a witness if he's a defendant. I mean, he's not cooperating with the prosecution with anybody else. I don't know how they were going to subpoena him, in a subsequent trial. I don't think he would probably not help the prosecution at all. And with this mistrial, I can't imagine that they would use him at in any stage of any proceeding against any other officer. I can't see how he would help them at all. Says
Officer Porter. I'm just reading from one of the reports out of Baltimore. Officer Porter is considered a material witness in their case against the driver of the van. So are you saying that they cannot call him to the stand in the other cases, or?
When you're a co-defendant in a criminal case, even though you're a material witness, you have a right to take the Fifth Amendment and not testify. The fact that he actually did not take the Fifth and testified in his own trial may have waived his ability to take the Fifth in another trial. So, they may actually call him. It's an interesting little legal maneuver that they would be using to use a co-defendant who's waived his rights to remain silent. It'll be interesting to see how that comes across, whether he's going to be effective as a material witness against one of his colleagues when he was effective in his own defense in his own trial. So this is going to be very interesting to see.
So a mistrial like this, there were 7 women, 5 men, 7 of the jurors were black. Is it typically just 1 or 2 people that hold out? What are the dynamics in these things?
Well, we always, as defense attorneys, we always are trying to figure out, the dynamics in the jury room. Of course, it's always secret. And sometimes when they send out notes, you can kind of get the feel of where they're leaning. This could be it could be an even split, 6-6, or 7-5. There's no way to really tell unless you're really part of the trial. It wouldn't be surprised me that it was probably more like 10-2 for not guilty on this case, based on my experience. But there's really no way to really predict which way they were leaning unless they send out some specific notes. And you can kind of gauge it. And sometimes afterwards they'll talk, but I think there's a gag order on this case, so the jurors won't be able to.
And you think the likelihood is the leaning was towards a not guilty, and a couple were holding out against that?
That's my prediction based on the evidence on this particular officer and the way they alleged his omissions. I think that it would be really difficult to convince 12 people beyond a reasonable doubt that he was, guilty of these crimes, or even one of them, even the assault case. I mean, there's a varying degrees of activity that they accuse him of, and they couldn't get one unanimous verdict. So I think they were leaning towards not guilty.
So the state's plan, could it change where they may decide not to go after all 6, or is that going to happen no matter what?
I doubt that they would crawfish at this point and just not choose to prosecute each of the people that have been indicted. I think they're going to each have their own trials, and they're going to each have their own, different set of jurors, maybe a different set of different result. So I think they're going to retry this gentleman. I think they're going to try the other 5. I don't think they're going to just abandon ship. Yeah. It's already, they have to save some face here, and I don't think they're going to do that.
The publicity involved, does that force them to do that in ways where they might not have if it wasn't in the news?
The publicity is definitely a factor. I mean, they've tried. I think they should try to get this thing out of Baltimore personally, but the judge denied that. But the publicity and the negative publicity for the state is going to be a big factor in what they decide to do. I just, this is a big, high-profile case, and when you have officers that are, these are 6 officers with multiple years of experience between them, when they're indicted for, there was no question they were going to get indicted, but there's always been a question of whether they're going to be convicted. Yeah. And this is obviously a very good indication that this is not a slam dunk. Okay, so this officer, it's a mistrial. How quickly can they get another trial for him going? From what I've read, they're apparently supposed to convene next week and get a new date. So it's just as quickly as they can set a date. They usually give, on a new case, you usually get 10 days to be prepared, if you can believe how quick the system allows generally. Yeah. But I would imagine there's going to be a new trial date by February on this case. It's just my guess. Do you think there's a chance in a case like this where all 6 will either have mistrials or will be found not guilty? There's a good chance, but unless wherever their strongest case is, that's who they have to go with next. I mean, I don't know if they've actually scheduled out each of the other remaining defendants, but there may be a conviction for the most culpable of the officers, whether it be the driver or anybody that had more connection to Mr. Gray. This officer apparently had some obviously dealings with him, but it was more in passing, it seems. But I think, I wouldn't be surprised if somebody is convicted, but there's going to have to be some substantial proof that transcends what they offered in this trial. In
a retrial, then, do they change the charges potentially, or just leave everything in place?
They can certainly amend the indictments or the charging instrument. They can drop certain charges. They can go with, but if they add any charges, I'd be surprised. I would not be surprised if they dropped certain charges that didn't resonate with the jurors in argument. But they can always add more charges as long as it's within the statute of limitations.
Defense attorney Scott Palmer, scottpalmerlaw.com. Scott, thank you very much.
Thank you, sir.